call the committee to order. Mr. Clerk, would you call the roll, please?
Mr. Chair.
Here.
Representative Slezak.
Here.
Everly. Huckleberry. LeBlanc. Lindbergh.
Here.
Stanley.
Here.
Stamas.
Here.
Bolger.
Here.
Hanson. Horn. Mr. Chair, you have a quorum. With your permission, I will hold the board open.
Thank you, Mr. Clerk. I need a motion to approve the minutes of June 8th. So moved by Representative Lindbergh. Hearing no objections, the minutes are approved. I also need a motion to excuse absent members. Representative Stamas so moves, and hearing no objections, absent members are excused. This time we're going to lay before the committee House Bill 6234 by Representative Mark Meadows. And Mr. Meadows, if you come up and explain, and also with you, you have Ken Borton from White Clouds Trail and Gaylord with you today.
Well, thank you, Mr. Chairman, for bringing this bill up before the committee. It's a pretty simple bill, as I think everybody in this room knows. We had an incident up in Gaylord where a citizen who was feeding the birds got accused of violating the deer baiting rules of the Department of Natural Resources, or the then Department of Natural Resources. I had this bill drafted so that incidental feeding of white-tailed deer and elk would not constitute a violation of the law. And there is an additional exception which is placed in the statute through this legislation that would accomplish that objective. There's an additional amendment, which I think will be distributed in a moment, because it struck me as I read this statute also that in subsection paren 2, where there's a definition of deer and elk feeding, the objective there is to regulate or allow the regulation of with regard to the depositing or distributing of feed to prevent wild, free-ranging white-tailed deer and elk from starving or for recreational purposes. And there's an additional amendment which targets that. It had the word in an area frequented by wild, free-ranging deer or elk, and I don't think anybody knows what that means, and I'd like to eliminate ambiguities whenever possible. And even in the original language of the statute, which we are proposing to be changed, there was an ambiguity in terms of how a homeowner might prevent themselves from violating the law when it talked about how you exclude wild, free-ranging, white-tailed deer and elk from gaining access to the feed. So I didn't know whether that meant a 10-foot fence or a 20-foot fence, or perhaps some other electric intervention which could take place. I don't think anybody really knows how they could comply with this. These changes will make this statute easily understood by ordinary folks who live out there. Even though the publicity with relation to the Gaylord incident is what brought this to my attention, afterwards, I think my wife and I were sitting in our cabin up north, and I was looking out the window, and I saw a couple of deer come up and start to nose around the bird feed that's out there, and I realized, we could be in violation of this now that we know that a deer might do that. Then I looked out on the other side of the window and saw the apple trees that still grow on that property, even though they haven't had any apples picked in about 40 years, so I don't think they're normal agricultural purposes, which is another exception here, and that would mean that maybe I need to cut down those apple trees, because now I'm attracting these wild, free-ranging, white-tailed deer and elk to my property for that purpose as well. So I think there are some problems with this language as it sits right now, and these changes will go a long way to giving ordinary citizens a direction on what they need to do. So I'd ask that the committee consider this amendment and hopefully pass it.